Welcome back. The Constitutional Court has ruled former President Jacob Zuma is legally obliged to give evidence before the Commission of Inquiry into allegations of state capture. The highest court in the land says Mr. Zuma has to obey all summonses and directives issued by the Commission. Let's take a look at this clip by Justice Chris Jaft delivering the ruling.
Regarding the rights of witnesses who appear before the Commission, we conclude that none of them have a right to remain silent. This right is available to arrested and accused persons and not to witnesses. However, Section 3, Sub 4 of the Commissions Act extends all privileges enjoyed by witnesses in criminal trials to witnesses in proceedings before commissions. These privileges include that a witness cannot be compelled to give an answer which would expose him or her to a criminal charge. But it is the witness who must claim privilege against self-incrimination by demonstrating how the answer to a specific question would breach the privilege. This privilege is not there for the taking by witnesses. There must be sufficient grounds that in answering a question, the witness will incriminate himself or herself.
It is not there for the taking by witnesses, so says Justice Jaft. What does this all mean? I want to bring in another better mind, Advocate Johan Du Toit, retired Deputy Director of Public Prosecutions at the NPA's Johannesburg office. Advocate, always a pleasure having you on the program. Welcome.
Good morning and nice to see you again.
So the phrase, "May I not respond, Chairperson, in case I incriminate myself." A phrase we know all too well now, repeated by former SA Chairperson Dudu when she appeared before the State Capture Commission. Talk to us, Advocate, about the legal parameters of this phrase.
Yeah, thank you, and good morning also to the viewers. Judge Jaft, in fact, when you played that clip, he really summed up the crucial part of that decision, in my view. And I think it's important, just before I answer the question, that we must just make sure that people understand that, remember, this is a commission of inquiry, it's not a trial. You cannot be found guilty or not guilty. So everybody appearing before the commission, they are witnesses. And as the judge very rightly pointed out, you have not a right to remain silent. No witness that you call in a criminal proceedings has a right to remain silent. But, as the judge very well set out, you have a right not to incriminate yourself.
Right.
And as the judge read his judgment, and it's on page 109 of the decision, where he clearly indicated, that it's not for the witness to take this offer of self-incrimination. You must apply to the judge and say to the judge, "Judge, I don't want to answer this question because this question may incriminate myself."
I want to just explore
then
that.
The judge must rule.
I just want to explore that a bit further. Let's just take a step back so we're all on the same page. So the right to remain silent is a right available to arrested and accused persons and not to witnesses. However, Section 3, Sub 4, as the Justice outlined of the Commissions Act, extends all privileges enjoyed by witnesses in criminal trials to witnesses in proceedings before the Commission. Did I get that right? Help us understand that.
You're absolutely right. You're absolutely right. Because remember, if you're an accused person, you have a right to remain silent. If I'm arrested on a charge and the police question me, I can say, "Sorry, I want to remain silent and I don't want to say anything." It's within my bounds. There's nothing wrong with it. So I think there was a confusion of this right to remain silent and self-incrimination. And I think the Constitutional Court made it very, very clear and made it very, very clear to Mr. Zuma, Mr. Zuma, you don't have a right to remain silent. Why? Because you're not the accused. You're just a witness. But because you're a witness, you have certain rights like any other witness, also in a criminal trial. Because if I'm a prosecutor and I call a witness, the witness cannot say that, I'm not going to answer questions. The witness is obliged to answer questions. And then maybe if he incriminates himself, that's another issue that maybe we can deal later. But the principle is very clear now from the constitutional decision, and you're absolutely right in summing it up.
So the witness who must claim privilege against self-incrimination by demonstrating how the answer to a specific question would breach the privilege. Justice Jaft was saying that the privilege is not there for the taking by witnesses. There must be sufficient grounds that in answering a question, the witness will incriminate him or herself. Are these grounds worked out before or after the witness has given evidence? What's the test here? How is it worked out?
One can maybe draw, just to give a practical example how it works in practice, and then maybe we can move to the commission so that you can just see how it works. Say, for example, I would call a accomplice or an insider witness as a state witness. Now, I know, because I've consulted with him as a witness, that he may give answers that will incriminate himself, because I want to use his evidence to link up with the accused. So before I call him, I would swear him in, the interpreter will swear him in through the judge, and then I would inform the judge. I said, Judge, I'm going to call a witness now that may incriminate himself on account of fraud, for example. Will you give him a warning that he must answer questions that even may incriminate himself, but at the end of the day, if he answers all questions freely and openly, at the end of the trial, after judgment is given, the judge can then say, I've considered your evidence, you've answered all these questions freely and voluntarily, you discharge from prosecution. So this is how it works in a criminal trial. Now, move it now to the Commission of Inquiry. Remember, the evidence leader hasn't consulted, for example, with Mr. Zuma. So that is why I think the Constitutional Court said, this is not for you, for the taking. You must now, if the evidence leader asks you a question and you think this may incriminate myself, you must raise the issue. Then it's up to the presiding officer, the Judge Johan Du Toit, to ask you, what is it all about? And then you must convince the presiding officer that the answer you will give will incriminate yourself on a charge of, for example, fraud. And as you can see on the screen there, that is the crucial section from the Constitutional Court judgment that Judge Jaft also basically informally referred to. Let's just read it together, because I think it's so crucial to understand this. However, it lies with a witness before a commission to claim privilege against self-incrimination. In the event of doing so, the witness must raise the question of privilege with the chairperson of the commission and must demonstrate how an answer to the question in issue would breach that privilege. If the chairperson is persuaded, he or she may permit the witness not to answer the question. Privilege against self-incrimination is not there for the taking by a witness. There must be sufficient grounds for him to, that in answering a question, the witness will incriminate himself or herself in the commission of a specific crime. So it's similar to what you do in a criminal trial. So I think what I like about this judgment is that I think the Constitutional Court made it very, very clear, and it maybe fine-tuned this thing, that you cannot just come in and say, I'm refuse to answer this question because it may incriminate. You must first lay a basis.
Right.
And the judge may even question you. But Mr. Zuma or whatever a witness, why are you saying this? Tell me more about this. And then it's my decision whether you are not going to answer the question. It's not just your decision. And I think that is a little bit of emphasis that the Constitutional Court made it very, very clear. And I must say, I like it. And maybe if you just go to the second slide, even if a person, for example, would give an answer that may incriminate him or herself, the further protection for that witness, as you can see on the screen there, is the amended section 8.2 of the regulations, which make it very, very clear. A self-incriminating answer or a statement given by a witness before the commission shall not be admissible as evidence against that person in criminal proceedings brought against that person, except in criminal proceedings where the person concerned is charged with perjury. So that is your protection.
Right.
Even if you as a witness incriminate yourself, I cannot go later when you are, for example, prosecuted, and I say, yes, but Mr. X or Mrs. Y, this is what you said before the commission, or am I using it against your criminal? That's not admissible. And I think the reason for that is the commission wants people to speak openly and frankly about things, even if they incriminate themselves, with the caveat that if you do that, it cannot be used against you in a criminal trial. You're protected against that. So I think the principle is here.
Right. I just want to explore that caveat, as you mentioned, at a commission of inquiry when there is a present public importance involved here. To what extent will not responding in case one incriminates him or herself prejudice public interest in the investigation of such important matters?
I think if you can use the example of Ms. Mayeni, when she exercised her right not to answer questions because it may incriminate herself, the judge explained to her that, Mrs. Mayeni, please remember now that in exercising that right of you, I cannot take into account what you have said when I prepare my final report, because the evidence that I've heard implicating you, I will now have to take into account without the benefit of your version. So you must take the consequences for that if you're not answering that question. And then at the end of the day, the judge can then make a ruling on the evidence that's before him without the benefit of the version of say, for example, Ms. Mayeni. And he will, in his final report, make certain conclusions. Remember now, he cannot prosecute people, but he can make recommendations that consideration must be given to prosecute X and Y on this count and this count. And then it's up to the NPA to decide finally whether or not they're going to prosecute that person.
I just want to get your take on something that I heard during the Constitutional Court ruling this week. And Justice Jaft said that this particular commission itself was established by former President Jacob Zuma in terms of the Constitution. And he added, it is therefore unacceptable that he, Mr. Zuma, is the one who, and in his words, frustrates its investigation. He said that this conduct is in conflict with the constitutional order chosen by the founding fathers and mothers of this nation. I want to get your take on that and what he meant by that.
I think he was basically saying that, you didn't say in so many words, but, my view is President Zuma has on many occasions said that, what did I do wrong? Or, this is a political conspiracy against me and, a lot of other things. Now, I'm not going to judge on that allegations. But what I'm just saying is that, Mr. Zuma, if you believe that that is true, now you've got a golden opportunity to come before the commission as a witness. You're not an accused. You're a witness. Come tell the commission now, in your view, why you didn't do something wrong, or why there's a political conspiracy against you to incriminate you. Tell us, be open. You're the president. You've been in high positions of power. You've seen many things. Take us into your confidence and disclose these things to us so that we can see whether this is in fact true or not. So, you know, I think that is for me the simple answer to this whole question. Mr. Zuma, come to the commission, tell us your side of the story. You will get a fair hearing there, and then we can take it from there.
We shall see how it plays out in the next couple of weeks or months to come. Advocate, we always appreciate your insight. Be well.
Thank you, sir, and good luck, and take care.
All right, take care. Advocate Johan Du Toit there, retired Deputy Director of Public Prosecutions at the NPA's Johannesburg office. We're going to take a quick break.